the following events might sound familiar. Boston is home to 3 exam schools, which are ranked among the top public high schools in the United States. For 20 years, an applicant's GPA, standardized test score, and school preference were the sole metrics for admission to those schools. In 2019, however, the Boston School Committee began to consider changes to the school's admission practices for the purpose of altering their racial and ethnic demographics. To that end, the committee convened a working group to recommend revised procedures for the 2021-2022 application cycle. After studying the issue, the working group presented a 2-step proposal to the committee in October 2020. First, students with the highest GPAs citywide would fill 20% of the exam school seats. Second, each zip code in Boston would receive a share of the remaining 80% of seats, proportionate to its population of school-age children. For those seats, the plan would rank applicants by GPA within each zip code and give assignment priority to zip codes with lower median household incomes. After the working group presented this proposal, committee member Dr. Lorna Rivera expressed her approval. She emphasized that the committee must be explicit about racial equity and increasing those admissions rates, especially for Latinx and Black students. Heeding Dr. Rivera's call, the committee put race front and center when it came time to vote on the proposal several weeks later. The meeting kicked off with a lengthy statement from anti-racist activist Dr. Ibram X. Kendi, who urged the committee to approve this anti-racist policy proposal that would close racial and economic gaps. Later, during the public comment period, the committee called on 3 citizens whose names suggested they were of Asian descent. Forgetting to mute himself on Zoom, the committee chairperson, Michael Locanto, mocked their names. Vice Chairperson Alexandra Oliver Davila and Dr. Rivera could hardly contain their amusement, noting over text message they almost laughed out loud at Locanto's gaffe. That was not all Oliver Davila and Rivera had to say. As leaked text messages later revealed, Oliver Davila told Rivera that she expected the white racists to start yelling at us during the public comment period. She went on to note that she hates WR, a reference to the predominantly white West Roxbury neighborhood of Boston. Rivera agreed, stating she too was sick of Westie whites. Locanto, Oliver Davila, and Rivera voted to approve the working group's proposal, but they all later resigned as a result of their racist remarks. The new policy worked as intended. Between the 2020-2021 and 2021-2022 school years, Black students increased from 14% to 23%, Latino students increased from 21% to 23%, white students decreased from 40% to 31%, and Asian students decreased from 21% to 18%. The Boston Parent Coalition, an organization of parents and children who have or will apply to the exam schools, filed suit. The coalition claimed the new admission policy, though facially race-neutral, violated the Equal Protection Clause. Except in extraordinary circumstances, intentional discrimination based on race or ethnicity violates that clause. But in this case, despite overwhelming direct evidence of intentional discrimination, the lower courts concluded that the coalition's equal protection claim failed because it did not show disparate impact. The First Circuit reasoned that, even under the new policy, white and Asian students remain starkly overrepresented compared to their population levels. This reasoning is indefensible twice over. First, the lower court's disparate impact analysis was clearly flawed. I addressed this point last term in Coalition for TJ. There, the Fourth Circuit concluded that a facially race-neutral admission policy caused no disparate impact on Asian students because they were still overrepresented compared to their population level. As I explained, that is a patently incorrect and dangerous understanding of disparate impact. But we failed to stamp out the Fourth Circuit's error when we had the chance. Now, the error has metastasized and spread to the First Circuit. Nonetheless, it bears repeating that under our decision in Arlington Heights v. Metropolitan Housing Development Corporation, all a party must show in order to rely on disparate impact as circumstantial evidence of discriminatory intent is that an admission policy reduced one racial group's chance of admission and increased another racial group's chance of admission. Second, and worse yet, the lower courts mistakenly treated evidence of disparate impact as a necessary element of an equal protection claim. To my knowledge, we have never said as much. To be sure, we have said disparate impact is possible evidence of such a claim and may provide an important starting point. We have also emphasized that disparate impact is not the sole touchstone. Further, a rigid rule requiring disparate impact evidence would make little sense. We would, of course, recognize an equal protection violation if the government had a malicious intent or purpose to discriminate against an individual based on his or her race or ethnicity. Proof that the government's action also injured the racial or ethnic group to which the plaintiff belongs, however, is not essential. In making such an error, the First Circuit rendered legally irrelevant graphic direct evidence that committee members harbored racial animus toward members of victimized racial groups. As the committee members made explicit, they worked to decrease the number of white and Asian students at the exam schools in service of racial equity. That is racial balancing by another name and is undoubtedly unconstitutional. We have now twice refused to correct a glaring constitutional error that threatens to perpetuate race-based affirmative action in defiance of students for fair admissions. I would reject root and branch this dangerously distorted view of disparate impact. The court, however, fails to do so today, so I must respectfully dissent.